The news is filled with stories about abortion law, a woman's right to choose, fetal rights, and public policy. So in this video, I want to look at the history of abortion and show how popular opinion was shaped by perceptions of nature, law, and evangelicalism. So by the middle of the 19th century, abortion in the United States was on the rise, due in part really because of a lot of wealthy Protestant women who really embraced this medical procedure as a means of maintaining social status. But by the end of the 19th century, Christian doctrine of fetal sacredness was undermined by this Enlightenment philosophy that emphasized nature over the action of God, and this Darwinian belief in animal-to-human evolution, which really undermined, again, this whole idea of human sacredness and enduring value of human, especially from the moment of conception. By the time we get into the early 20th century, we see a lot of movements like the Eugenics movement that were trying to emphasize raising more pure and better human species. And so at your typical 4-H fairs where you're looking at the livestock and all these other things and you're evaluating them on their strength and fitness, we could see examples of this across the United States where humans were put in the same kind of pavilions and graded on their racial fitness. And this quote here is kind of interesting. While the stock judges are testing the Holsteins, Jerseys, and white faces in the stock pavilion, we are judging the Joneses, the Smiths, and the Johns. So humans began to be seen as these sort of more fit or stronger, better animals who could be bred into higher quality fitness. And so anything with a defect was considered not worthy of life. Now jump ahead to the mid-late 20th century, and we can see this evangelical perspective on this idea of abortion and where it started to take place. So here's a resolution passed at the St. Louis meeting of the Southern Baptist Convention in 1971. This is before the case we're all familiar with, Roe v. Wade. And this resolution said this, quote, "We call upon Southern Baptists to work for legislation that will allow for the possibility of abortion under such conditions as rape, incest, clear evidence of severe fetal deformity, and carefully ascertained evidence of the likelihood of damage to the emotional, mental, and physical health of the mother." So this was a pretty broad definition of what the Southern Baptists, as a Protestant evangelical organization, believed were the right conditions that would allow for abortion, even in this broad definition of mental and physical health and well-being of the mother. So this collection of ideas, these Enlightenment ethics, this Darwinian worldview, this naturalistic framework, alongside a shift in Protestant theology downplaying human sacredness, especially for the unborn, really set the stage for this legal perspective that was crystallized in 1973 in the famous case we all know, Roe v. Wade, where the Supreme Court of the United States, SCOTUS, declared women had a constitutional right to abortion. Now, what SCOTUS did was they marginalized the Hippocratic tradition of human sacredness that was embraced certainly by early Christians, and they said this is really a minority position. Justice Blackmun makes clear reference to the fact that both Plato and Aristotle affirmed abortion and says in the decision, quote, "The Hippocratic oath was not uncontested, even in Hippocrates' day. Only the Pythagorean school of philosophers frowned upon the related act of suicide. Most Greek thinkers, on the other hand, commended abortion at least prior to viability." So he refers to Plato's Republic on that. Now, what's interesting, Blackmun doesn't mention that in Plato's Republic, he also affirmed not just abortion, but eugenics and infanticide. And so this affirmation of a counter-narrative against the Hippocratic tradition as a minority tradition that shouldn't be respected in U.S. law really took shape not just for Roe v. Wade, but future conflicts we see over and against the issue of human sacredness and preserving human life. The other key aspect of Roe v. Wade is it extended the right to privacy based on the First, Third, Fourth, and Ninth Amendments. Now, these were decided in Griswold versus Connecticut, which was a contraceptive rights case back in 1965. But most importantly, this decision said that the states could restrict second and third trimester abortions with compelling interest. So it did reserve the rights of the state to restrict or regulate the abortion procedure in these later terms. But now, interestingly enough, what it gave with Roe v. Wade, it sort of took away on another case that SCOTUS decided on the exact same day as Roe v. Wade. This case is called Doe v. Bolton. Now, this decision broadly defined a woman's health, like we saw for the Southern Baptists, to include psychological, emotional, familial, age, and physical factors. So these factors really, in essence, nullified the state's ability to limit abortion in these later periods. So, in other words, a doctor could say, hey, well, this is just in the woman's best interest, or this would help her mental state, and the state really had no foundation to come in and place restrictions on that. Now, but at the same time, we see a really interesting statement by a guy named W.A. Criswell. He was a former SBC president and a pastor of First Baptist Church in Dallas, Texas, which was really one of the more significant Southern Baptist churches at the time. And this is, again, right after this Roe decision, he says this: I have always felt that it was only after a child was born and had a life separate from his mother that it became an individual person. And it has always, therefore, seemed to me that what is best for the mother and for the future should be allowed. So here we have within Christian theology this very naturalistic perspective that the fetus is not a human person until after birth, and therefore anything in the interest of the mother justifies or is an acceptable cause for abortion. And so this was a strong influence and reflection of many evangelical minds during this time. Now, there's one other case that's really important here. In 1982, SCOTUS decided Planned Parenthood versus Casey, which rejected the trimester distinction in Roe v. Wade and created the new standard of what's called fetal viability. This removed the more objective measures set by the calendar, second, third trimester, and shifted the right to abortion to a standard that was far more subjective and dependent on technological advance and really access to medical care. Because now a fetus was protected, I guess, in that sense, depending really on, well, hey, is it viable earlier or later, depending on new medical techniques available? And really, if somebody has access to better doctors, a fetus could be considered viable for that mother, whereas a fetus for somebody who was poor may not have a fetus considered viable. So it really became a very external standard having nothing to do with the fetus itself, really, but more based on medical care and practice. Now, understand, even with this new Casey standard of fetal viability, the individual states could still regulate and even ban abortion after this period of viability, but this government power was still limited by the broad exception of a mother's health. Now, this gets into some of the philosophical aspects to this court decision that are really problematic for the Christian. So the court ruled that, quote, the right to defend one's own concept of existence, of meaning, and of the universe and of the mystery of human life is the heart of liberty. So in other words, they said there is no objective measure or standard of what it means to be a human being. There's nothing inherent to the individual that makes their life worthy of life. This is really left up to the individual mother and her pursuit of liberty, and she can decide what gives meaning to the life of the unborn child. Now, the other key part of Casey involved parental rights and paternal rights. So the court upheld parental consent as an option for each state to decide. So that meant that any state could say, well, yes, you are required for a minor to notify the parents, or you're not required to notify the parents. And that's why we see a lot of differences between one state to a next, depending on their legislatures and what they believe is this option or need to notify a parent of their minor child wanting an abortion. And the second part that really the court struck down the husband's rights, the rights of the father. They said this part of the Pennsylvania provision was unconstitutional that required a wife to notify her husband that she was getting an abortion. So this brings up the big question: what is next for SCOTUS? It is difficult to say what the U.S. lower courts or SCOTUS will decide next, or what direction the evangelical church will go. But as you consider your own view of abortion, I hope this video offers you some useful insight by showing how the influence of Darwinian naturalism, the law, and theology have shaped the abortion debate.